I mean, I just don't understand this. What was they thinking? What's going on, guys? I'm Donnie, and this is WFMG, bringing you the top stories in black culture, news, and politics. If you're new here, welcome. Consider subscribing and hit the notification bell to stay current on all the new videos that come out. You will get notified. Every time I drop something, you'll get that notification. So hit the bell right now. I'm gonna wait. Hit that bell right there. Yeah, there you go. Now today, I come to you guys after almost 2.5 weeks, almost 3 weeks hiatus. I don't know about you guys, but I've been really not feeling great about creating and about life in the United States. If you're watching this, you probably already have seen the protests and the George Floyd video and the countless other stories of police brutality this year in 2020. I mean, if you guys have watched the first video on my channel, you already know I myself was a victim of police brutality. I couldn't understand, like in the aftermath of my case, I couldn't understand why the officers that did that to me and my family, felt like they could get away with that. And I couldn't understand that, and that's one of the things that has plagued my mind for so long, until I heard of the term qualified immunity. So in a nutshell, qualified immunity is basically a legal doctrine that was created by the Supreme Court in 1967 that says public officials and police officers will be shielded from liability unless they violate a constitutional right, part one, and part two, they have to have violated a right that has already been clearly established. Now, when they say clearly established, what they mean is the court said that the victim must point to a previously decided case that involves the same specific context and particular conduct. Unless the victim can point to a judicial decision that happened to involve the same context and conduct, the officer can be shielded from liability. Now, this makes it incredibly difficult for people to sue the police because there are so strict context rules put in place over the situation of policing that unless it happened in the exact same way, you lose the case. And this is like ridiculous. In 1967, the Supreme Court decided a case in which two police officers and a bunch of clergymen got into it at a bus station. The officers saw a sign that said whites only. They began to harass the clergymen that had like a few black members. The majority of them were white, but there were a few black members, and they started to harass them. So when they wanted to just proceed and get their coffee and go to the next place, the officers said no and arrested them and held them for what seemed like 4 months. Needless to say, this law or this doctrine, this legal doctrine, was an offset of a whole bunch of other meaningful, positive ways to try to end civil rights abuses in the United States. So let's start the story off way back in 1871. So in 1871, this is the period of Reconstruction. This is after the Civil War. People fought, the North and the South fought, yada, 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 it's done. Slaves are free, we all chilling, we good. Now, of course, there was a lot of white rebellion in this time, and there was this huge, overwhelming fear of retribution. The United States was in this period where they needed to bring back in all the slaves who were enslaved and all the people who were enslaving them back into the United States, back into the government. So they created the Civil Rights Act, which basically said that every person living in the United States that's a citizen is protected under unreasonable violation of their rights. And the person that violates their rights can be held responsible, financially responsible. So they go on to say in Section 1983 of the U.S. Code that if a public official violates your rights by way of police brutality, illegal search and seizure, unlawful arrest, they can be held responsible financially. It says every state official who causes a deprivation of any rights guaranteed by the Constitution and laws shall be liable to the injured party. Now, needless to say, this was a step in the right direction. And this is way back in 1871. So things had been getting better and worse in some ways. Whites since then had created the Ku Klux Klan and Jim Crow laws and all these things to oppress black people. Let's fast forward to the 1960s. So it's the 1960s, we're in the throes of the civil rights movement, and black people are rising up and fighting back against oppression and against racism. So there's this civil rights case called Monroe v. Pape. I hope I said that right. Monroe v. Pape. It happened in 1960. So this story is a story of a black man and woman asleep in their home with their 6 children. At nighttime, pretty much same story as my family. Police officers ransacked their house, woke them up out of bed, made them stand in the living room butt naked while 12 officers ransacked their house and literally destroyed all of their belongings. The father was then arrested and taken to jail, but they did not charge the father. They did not bring him in front of a magistrate. They basically violated all of his civil rights, held him for 10 hours, and then released him. Strange. Now, that family sued the police, and eventually it got all the way up to the Supreme Court, where the Supreme Court held that the black family wins the case and that the police officers had violated their rights and it was wrong. Now, 7 years later, this is around the time that Nixon comes into office. Okay, 7 years later, they decided a case called Pearson v. Ray.
We think that the intent of the Congress of 1871, from reading the Congressional Globe at that time, is so carefully drawn against the sham justice that was perpetrated in the period from 1866 through the period of 1871, that the very kind of conduct that is concerned in this case is the kind of conduct the 1871 Congress was concerned about. They were concerned about the phony justice, the sham justice, the police who arrest and the judges who convict when there is no evidence of any wrongdoing.
This case goes all the way up to the Supreme Court. The Supreme Court justice basically created this legal doctrine that says there's 2 parts to qualified immunity. The first part is, does this conduct violate a constitutional right? And in that case, it did violate a constitutional right. And the second part of it states that, was this a clearly established right? Now, what this means is, at the time of the incident, had the same facts of the case been decided and already won upon? If you can't find a case that matches exact fact patterns and upholds a certain precedent, then you basically lose the case. And this is why it's such a problem with qualified immunity, and it's so hard to prosecute the police on this doctrine, because literally they can do a different thing each time and win the case. And that's, obviously that's a problem. I think I just want to just undernote that the female lawyer that was actually arguing the cops' side of things.
Beside the issue in this case, we don't have to go that far. We don't have to go whether there be any actual corruptness, because there was none. There wasn't any evidence of anything except the judge giving his best judgment. Which I'd like to get to the immunity of the police officers, because if there's anyone that I feel stand here that needs representation and that I would like to do my best to represent, it is the policeman on the beat in these troubled times. When he doesn't know what to do, he has to make snap decisions. He has no lawyer running along his side to tell him what the law is or what the facts are or whether he's right. He can't remember afterwards. Take all this CUD in this past summer, the thousands of arrests where policemen have arrested people, where they have thought at the time that they were justified. Suppose one of those men 3 years later says, well, I was acquitted. The policeman doesn't remember him. He hasn't gotten out and gotten witnesses and getting names, getting ready for a lawsuit 3 or 4 years from now. He doesn't know what the fine points of the law. He's got to use his best judgment in whether or not there's violence about to occur. And that is what we submit. That is the common law immunity of police officers. It goes as far back as the immunity of judges. If they have reasonable grounds to believe that there's probable cause of violence, then under the common law breach of the peace, they have a right to make an arrest without a warrant. In other words, probable cause is a complete defense to a police officer for a suit for damages at common law. There's no
Basically stated that, police officers should be awarded immunity as well as judges should be awarded immunity. And when she said that, I think at that moment what they started to think about was their own implications on whether or not they could be held liable under the same statute. Because what it says is that any person that violates the right, any official that violates the right can be held liable. So if you're deciding a case where someone basically says, okay, well this person, if this goes for this person, shouldn't it go for you too? I really think that the implications of qualified immunity go directly to the heart of whether or not public officials should be immune to liability or not. Because corruption, right? Corruption is one of the things that the founding fathers wanted to fight against, right? So if we have this whole idea that we don't want corruption, then we need to make a law of the land, and in that law of the land, no one needs to be above the law. Everyone needs to be held accountable for the shit that they do. Now fast forward that to now, and you have police officers kneeling on someone next for 8 minutes and 42 seconds and not think anything's gonna happen to them. You have police officers stealing $225,000 on the job because it has never been clearly established whether or not police officers could steal while executing a warrant. I mean, the perversion of the law is just, it's astonishing. God damn it, this is fucking... But here's the thing, there's right and there's wrong. And every person needs to make a judgment on whether what they're doing is right or wrong. And every person will be held responsible for that judgment on whether it was right or wrong. I mean, there are laws on the books where you don't even have to have intent to be guilty of. So why are we hinging this on intent? We just need to hinge it on whether it was right or whether it was wrong. Until we realize as a country that nobody is above the law, there's always going to be this tit for tat. There's always going to be this secret hand of the government that is really going to just control and let go of liability for the shit that they do to people. Dave Chappelle also spoke on the George Floyd matter. I guess it was just a stand-up special, but he was supposed to be doing comedy, but it wasn't really funny, like in a ha-ha. There was funny moments, but here's the clip.
I wouldn't have to remember myself being vocally terrified, but I forgave myself for being terrified. That earthquake couldn't have been more than 35 seconds. This man kneeled on a man's neck for 8 minutes and 46 seconds. Can you imagine that? This kid thought he was gonna die. He knew he was gonna die. He called for his mother. He called for his dead mother. I've only seen that once before in my life. My father, on his deathbed, called for his grandmother. When I watched that tape, I understood this man knew he was gonna die. People watched it. People filmed it. And for some reason that I still don't understand, all these fucking police had their hands in their pockets. Who are you talking to? What are you signifying? That you can kneel on a man's neck for 8 minutes and 46 seconds and feel like you wouldn't get the wrath of God. That's what is happening right now. It's not for a single cop, it's for all of it. Fucking all of it.
And there it is. Dave Chappelle said it best. I mean, he ended the series by saying, this is our last time to show you that we want to protest against the inequality, and after this it's just rat-a-tat-tat-tat-tat-tat-tat. I mean, I guess you guys understand what that means. I mean, people are protesting, they're showing their own voice, they're using their own voice to stand up against, police brutality and, segregation and racism and all the shit that has plagued us for all these years. So now let's talk about where we go from here. Right now in Congress, Ayanna Pressley and Justin Amash have introduced a new act into Congress. This is called the End Qualified Immunity Act. With this act, they hope to create the distinguishment that qualified immunity is not a defense for police officers to violate the rights of human beings. And it's up to you as citizens to call your members of Congress and get on them right now about voting to pass this act into a bill and then this bill into a law, because we really need this reform. If a surgeon is on the surgery table cutting and dissecting someone and they killed someone, are they going to be held liable? Yes, they are. So why should a police officer or a judge or anyone else for that matter be held to any other standard? And the best way to enact change or to put your voice down is to vote, and it's to contact your local government, contact your state and local government, contact the federal government, whoever you can contact. Make sure you contact them and tell them to vote the right way on this bill, because it's everyone's life depending on it, to be honest. So I've got more to say, but I will say it in the comments. Please tune in next week for another video. If you have any other questions, comment below. You know how to reach me. I will be doing a live video sometime this week on Instagram. Thank you guys for sending the love my way. Thank you guys for all the love and support you showed my mom after our last video. We will be doing another live session sometime next month. Like, comment, and subscribe on all these videos, and keep coming next week for more content. Peace. I gotta go.